Hello and good evening and welcome to another program on Law and Order. Now, with the globalization becoming inescapable and more countries are interdependent and nationalism is largely frowned upon, the international or global trade has gained much significance than ever before. Now, strengthening the necessity for the international trade were the remarks that were made at the recently concluded G20 summit. They remarked, it is important to have mutually advantageous trade and investment frameworks in order to strive to ensure a level playing field. This was basically their concluding remarks. Now, in this backdrop, it is very vital that people who are engaged in international trade or otherwise, and the lawyers, know or have a deep knowledge on the international trade law. Now, in the program Law and Order, we have not touched this topic before, but today we thought it's timely. And in order to do that, like always, we have a special guest, a specialist in that area. And my specialist and special guest is none other than President's Counsel Chandaka Jayasundera, who is a specialist in international trade law. Chandaka, thank you very much for taking time off and coming for Law and Order. How are you today?
Good.
You're good. Thank you. Right. Let's start with a basic question, which anybody would ask you. What is international trade?
Okay. International trade is basically, in the very basic form, is trade of goods and services internationally. Right. Now, present day, it's also referred to as cross-border trade. Those days, it was always international trade, but presently, the subject has gone into what is called cross-border trade. So, anytime goods or services crosses a border, that is international trade. That is, you have the domestic trade within a country, but immediately you trade with another country or some entity in another country, that becomes international. So, there are laws that is outside the basic domestic law which deals with international trade. But basically, any trade between two people or two entities in two different countries.
Right. Now, if I ask you further to elaborate on for benefit of our viewers, the components that constitute this?
Component means it constitutes everything in a transaction between two people in two different states. So, if you take as an example, say for example, if you take a garment factory in Koggala, sells garments to a buyer in the United States, say let's say Boston, then everything, every transaction, every dealings between those two people and the attendant transactions on the carriage of the goods from the factory to the ultimate buyer is in international trade. So, you will have the basic contract of sale, then you will have a contract of transport, then you will also have ancillary to the contract of transport, you will have freight forwarders doing logistics services. Then you will, subsequent to that, you will then have the payment procedure. So, how is the price with regard to the contract of sale, how is the price paid? Yeah. So, that brings you into international banking and banking practices and payment procedures in finance. Then you get insurance, that is insurance of the goods from factory to delivery. Insurance, then you have customs, which is not actually within international trade law, but ancillary to that. So, that entails from start to finish, whatever law that deals with or impacts on a transaction will be applicable.
Okay. This would also mean a service.
It does. It doesn't mean merely sale of goods alone. It can be services. It can be, say now at the moment it's developing into what is called logistic services. So, you have what are called 3PL, 4PL, that is provision of logistics by third parties for companies. So, now in international trade, even provision of warehousing, provision of transportation, those are all done by third parties where a company will outsource it. So, those are services. Those also come within what is called international trade.
Right. Now, I know the laws are many dealing with, but if I may ask you, what are the laws that are, we'll go to detail later, but basically dealing with international transaction. If I may to explain further with a question, example, we will say somebody manufacturing something here, the same example, factory garments, and selling it to a company in US. What would be the laws that involve?
Yeah, so as I said earlier, you will have the basic contract of sale. So as far as that is concerned, in Sri Lanka is the carriage of goods by, the sale of goods ordinance. Then it will also depend on the law that is prevalent at the destination, port or destination, where the delivery buyers is. So basic is the carriage of, sale of goods ordinance. Then with regard to transportation, you will have the carriage of goods by sea act. As far as sea carriage is concerned, that is generally governed by what is called the Hague-Visby rules or the Hague-Visby Convention. Then you will have the general domestic insurance law. And then with regard to financing, you will have the general international banking law. And depending on the method of payment or the transaction, you will then have what is called the UCP, that is Uniform Practices of Banking. Then collection, that it depends on the transaction. So you will have, those are not specifically laws, but generally internationally accepted methods of payment. Then so insurance and transportation. So carriage of goods by sea, if it is by air freight, it will be the carriage of goods by air or the Air Navigation Special Provisions Act. Then if it is, now it's not prevalent in Sri Lanka, but in Europe, you will have a convention relating to transport by road and transport by rail. So depending on the transaction, depending on how the carriage is taking place, there will be different laws. So if it is, for example, that is just cargo, if you put your cargo in a container and then that will take, say for example, we'll take the same example, it's easy. So from Kaggala to say either Hambantota port or Colombo port, it will be road transport. So that is one specific law, which is not, we don't use it much in Sri Lanka, but in the United States and in Europe, there are specific laws for road transportation.
Road transportation is something that dealing with the product that is going out. Is that what you're saying? No.
It depends on, because especially in Europe, you have, because there are no borders there is a lot of inter-border transport. So from then, if it is from Colombo port, it goes to say wherever in the United States, that segment of the transportation will be under the Carriage of Goods Act or the Hague-Visby rules. Then if you take United States, from the port, there will be internal transport to the buyer's warehouse. So you will have rail, then there will be a different law for that. Then you will have say road transport, you will have a different. So each component will have different laws. Now that is called, what is called multimodal transport, that is the usage of different modes of transport. So you have road, sea, road, rail. So that is called multimodal transport. That is a new field of law which is expanding. There are a lot of problems as to how it is applicable, but individual laws will depend on the individual mode of carriage.
Right. Now, you must have been dealing with so many of these issues, clients coming to you. What are the legal ramifications you see when you are doing international trade? Either the same example or a continuing big example?
No, the ramifications are vast, because the problem in international trade is most of the time the person you are claiming against or person you are claiming from or who has breached the contract is not within your jurisdiction.
Right.
So it will be most probably, if it's a buyer who doesn't pay on the sale of goods transaction, the buyer will be somebody in the United States. So, and then if it is a dispute arising out of the contract of carriage, the ship owner might be in Singapore or Malta or wherever, or Greece, registered in Greece. So that is the biggest problem, that your opponent or the person you are claiming from is never within your jurisdiction.
Right.
So as long as he is within jurisdiction, it's very easy, because you know where to catch him or where you can proceed against it. But the problem in international trade is, it's most of the time the person you are claiming against is somewhere else.
Yes.
Then the other legal ramifications is, although it is one transaction where one person sells goods from one country to another, there are so many other laws that impact on that transaction. So it's not Say if it is a domestic sale of goods transaction, it will be just the sale of goods ordinance. But internationally, there will be the transport component, there will be the insurance component, there will be other, say for example, multimodal components. So that is the other, the area is vast. So you need at least a basic knowledge of each component of your transaction to get at least figure out what is happening.
Right. Now, you said a very, very crucial question about person defaulting a contract on international trade. Now, how has the law dealt with, because this is like you said, about 90% of the time people are on different jurisdictions.
Yeah.
So it's difficult. And how do you get about settling such a dispute?
See, if it is an international contract of sale, that is under the sale of sale of goods, most of the time that is controlled by the payment method. So the way you get payment is structured in a way that until such time the buyer gets the goods to his satisfaction, the payment won't take place. In the same way, there has to be a protection for the seller who gets rid of or who hands over the goods, that the goods are now gone and you don't have payment. So you don't have money. So that is generally covered by basic provisions of international banking. So the most safest way of doing trade is what are called letters of credit, which means that the bank acts as a custodian, or more than a custodian, acts as a channel. So the bank will not release the money to the seller until the goods are safely in the hands of the buyer to the specifications required by the buyer. In the same way, so that means the buyer doesn't lose the money until he is satisfied the goods are there. In the same way, the seller is guaranteed payment as long as he does his job or his obligations under the contract of sale. So the bank acts as a conduit, and as long as that conduit, that system works, there is no problem. That is the most safest way of doing it. Then you have what are called collection agreements. That is when the buyer and the seller are known to each other. There is no say, it's not like a initial transaction, first transaction or something. Then you have where they are more friendly with each other, they will have what are called collection agreements. That will be documents against payment. That is, the documents for collecting the goods will be done only upon payment to the bank, or documents upon acceptance. That is, you accept to pay the price for the goods, and the bank permits the delivery of the goods. So those have like 90-day credit, 60-day credit. So those are what are called collection agreements. Then you have the people who have traded a lot together, they know each other, they know the risk and all that. Sometimes they do it on direct bank transfers. So the more biggest protection that is given is by the financial sector, so, or the banking law, so that you don't lose out on some your customer getting the goods without actually paying. Of course, there are enough and more instances where it happens. In those instances, there are other ways of doing it, but generally you are protected if you use a very well established money payment system.
Right. Now, if I may ask the same example of goods, the clothes going, for example, okay, the money is withheld. If, for example, the guy in the United States or somewhere checks the goods is not according to his specifications, he'll return the goods and the money is not paid. Now, what if a situation like this, I'm asking whether you have any remedies. We'll say a guy in the US wants a particular kind of clothing, winter clothing, ordered from Sri Lanka, and the clothing doesn't come to specification, and it's winter time. And he has no time to place another order. Do you have the normal, in addition to not releasing the money, are you able to invoke delictual rights and sue for damages, and if so, how it is done?
You have, because most of the time these time specific, especially for example Christmas, and then when the quotas used to be, it was imperative that the goods go before the 31st of December because of the quota is for a particular year. So in those circumstances, the parties can agree that this is the specific, and that it is essential that the time periods are adhered to. Then if that is agreed upfront, Then if there is a breach of those, say for example there is a clause which is time is of the essence, that is you have to do it as soon as possible and reasonably possible, or where you say it has to be shipped before the 31st of December or specific time, a breach of that would amount to a fundamental breach of the entire contract. Then subsequent to that, you can put it in your agreement that if something like that happens, you are entitled to claim for what are called consequential losses, because most of the buyers of garments and other exports from Sri Lanka are people who on-sell to the retailers. They are not retailers.
Right.
So what they have a problem is when the goods don't come to them, the supermarket shelves are empty. So those are the normal claims, especially when there are damaged goods or goods that don't meet with the quality. The issue is the consequential damages they have suffered because they are on sellers, that is the retailers will be suing them for not providing the goods on time.
Now most of the time when there's an issue like this or some bigger major issue of bigger goods, where is the action file? Is it, if I may elaborate my question, is it like, even Sri Lanka has agreements of foreign judgment enforcement agreements with certain countries. Is it the most wiser thing, is it to file action in their local country and to try to enforce it in that country provided we have an agreement, or is it wiser to use alternative dispute resolution mechanism like arbitration?
Yeah, the problem in filing action in our jurisdiction for a claim against a defendant in some other jurisdiction is that first you have to satisfy the jurisdictional territorial requirements of the court here.
Right.
So most of the time in international trade there will be problems about where the cause of action arose.
Right.
Most probably it might be somewhere on the sea or somewhere, right? Then defendant is definitely not within jurisdiction. So getting the jurisdictional qualification to go to court in Sri Lanka might be difficult. But if you do satisfy that, the next problem is that the enforcement procedure, that is generally what is it's done under the reciprocal enforcement of foreign judgments ordinance. Now that was originally, when it was introduced by the British, it was okay because it applied to all British colonies. So at that time everybody, practically half the world was or more was British colonies, so there was no problem. But now it has come to a point that we can enforce our judgments only in England and some countries in the Caribbean, which still come within what is called the Queen's Realms and Territories.
Right.
So till 1997 we could enforce judgments in Hong Kong.
Yes.
But after 1997, Hong Kong went out of the realm of the Queen.
Yes.
So now we are left with basically England and some countries in the Caribbean and I think the Pacific.
Yes.
So that is not an option anymore unless your defendant is in the United States, in the United Kingdom. There is, I think, if I am not mistaken, the Law Commission has been trying for a long time, there is a reciprocal enforcement treaty that or convention that is in operation to try and get it into law here for a long time. I don't know.
That is for which countries?
That is generally most countries are covered by that.
People who ratify the treaty.
Ratify the convention.
Have you ratified the convention, Sri Lanka? No.
I think we have entered into it, but I am not 100% sure of the details. But I know it's stuck somewhere.
Okay.
Right. So that is a problem. Now, alternate dispute resolution is.
So if I may interrupt you, so what you're saying is, even if we have ratified agreement, most of the countries, still having to go through a domestic court system will create problems, right?
Going through the domestic court system will create a problem. One is the fact that even if you get judgment, you will not be able to enforce it unless you have the financial wherewithal to go to that country and enforce it in that country. Most instances go and file action again. The attraction, so there are other ways of doing it, like for example with regard to shipping, specifically claims arising out of in respect of ships, then there is admiralty jurisdiction, which is a complete different subject, but there you have a right of getting what is called prejudgment security. There is also something, there is a concept called a Mariva injunction, where there is value or there is assets of the defendant within the country. There is a system of obtaining an injunction stopping that person from removing that asset from the country. right? That is called Mariva injunction, which is applicable and available in Sri Lanka. But for that, there must be some asset of the defendant within the jurisdiction, then you can freeze it. Now in England, Mariva jurisdiction or the Mariva injunction has been expanded to a certain, so great extent that they can give a injunction or freezing order, freezing all assets or disposition of assets of a defendant anywhere in the world, which is called a worldwide Mariva injunction. But that has not been used here or not tried here yet, but normal Mariva injunction can be done.
What about using the ADR mechanisms?
ADR, that is alternate dispute resolution, if you are looking at it on a legally, whether you can enforce it,
Yes.
then the most attractive is the arbitration process. Why the arbitration as a dispute resolution process is attractive is that I think almost 90 or 95% of the countries in the world have ratified the New York Convention.
Right.
In 1956. So anyway, 56. Now the New York Convention, any country which has ratified the New York Convention and any arbitration award that is made and delivered in a country can be enforced without much of a problem in any other convention country. So if an award is made in Sri Lanka and say, if I say, let's say Venezuela is a convention country, there is very little, it's very, very easy then to go to Venezuela and enforce it, because Venezuela under the convention rules is bound by international law to recognize an arbitration award made in Sri Lanka. In the same way, if somebody gets an arbitration award in Venezuela, the same way they can come and enforce it here. So as far as the enforcement process is concerned, arbitration is the most attractive.
Yeah.
It has problems because it's very, very costly. And most of the time people would want the arbitration to take place in a neutral country.
Yes.
Especially most people don't want to come here for litigation.
Yes.
So as far as Sri Lanka is concerned, the preferred is either London, which is very expensive, then it was Singapore, but now Singapore is also very expensive. Sri Lanka as an arbitration hub or whatever, has not developed.
Yes.
So we have our inherent problems here, so arbitration is not taking off here. So then you have to go to Singapore or England or Dubai or wherever. Process is very, very costly, or Paris, process is very costly, which is a problem in arbitration. But the attraction is the enforcement procedure. Other methods of other methods of ADR like mediation is also very attractive in the sense that it's being promoted here also, especially commercial mediation. It's attractive because the attendant costs and everything is not, there's one mediator. Most of the time it will finish in 1 day, 2 days maximum. Of course, that is an agreement. So there are problems there, but mediation is, and normally mediation means there's a settlement of the dispute. So enforcement most of the time doesn't arise because the parties themselves say, okay, we'll settle it this way. Conciliation, of course, that is just like negotiating and settling it. So basically the most attractive insofar as enforcement is concerned is arbitration. Most attractive in the sense that ultimately both parties end up winning something. It's a win-win solution, is definitely mediation. But enforcement of mediation is difficult. There is no legal provision for that.
Chandaka, Jayasundera, I know we have lots more to go in deep if you are going, but thank you very much for those insightful thoughts on international trade law, and thank you for joining us. Thank you for joining.
Thank you very much.
Thank you. That's Law and Order for you today. We'll join you next week at the same time with another episode of Law and Order. In the meantime, you can go to our Facebook page, Facebook.com/Law and Order Channel Line, and post your comments or your queries you have on there. Have a good night. Enjoy the rest of the programming in Channel Line, and have a good weekend.